Hello and welcome to another very exciting episode of your number one legal talk show, The Courthouse, where we get to learn the law together, our Law Class 101, as I fondly call it. I am Olomu-Agbodo. First, we'll go on a quick break. Stay with us.
If we have to give you anything, then we have to give you everything. Longford Plus Channel 465 is simply the best. Because we have something for every member of the family. So dads, keep the team spirit going on with our intriguing sport highlights and reviews. And moms, cooking is never boring when you have our intriguing drama series. And for all your lovely kids, just sit and enjoy. This, and oh this. I told you, we have something for everyone. Because we are indeed all about you. So keep it locked on Longford Plus Channel 465 on Star Times.
You're welcome back. This is the Courthouse with me, Olomu-Agbodo. And this week on the show, we are delving into a very interesting topic. A topic that basically sends a lot of Nigerians out of their houses every Saturday or every other weekend. And it is marriages. Marriages are different. There are different types of marriages, basically, which you are going to be finding out this week. But we are looking at marriage under the law, what constitutes a valid marriage. And as usual, we are joined by a seasoned legal practitioner, and she is S.A. James-Omokaro. You're welcome to the Courthouse.
Thank you very much.
Okay, so the marriage, what constitutes a valid marriage under the law, first of all?
Okay, I think I should start by defining marriage.
Yes.
Yes, marriage is the union between a man and a woman.
Thank you for that specification.
Yes.
Okay.
So for a marriage to be termed to be valid under the law, there are different requirements as provided for under the Matrimonial Causes Act and the Marriage Act. That is the enabling law. Now, one of the conditions is that the parties to the marriage must be single at the time of the marriage. It's very important that none of the parties must be in a subsisting statutory marriage or even traditional marriage to anybody.
Okay.
The only person that you can have a statutory marriage to, that you marry under customary law, is the same person that you can marry under statutory law. I don't know if you understand that.
No. You are going into, I think you are going very far right now, because now you've talked about statutory marriages.
Yes.
First of all, you're going to tell us about statutory marriages.
Okay.
Then you also talked about customary marriages.
Yes.
So maybe we should go into types of marriages
first. Okay,
yes.
fine. Now, under the law, we have two types of marriages.
Okay.
You have statutory marriage, then you have customary law marriage. By virtue of the Matrimonial Causes Act, even Islamic marriage falls under customary law marriage. So customary law marriage is polygamous in nature. That is, most people who are part of it, you can have more than one wife.
Wow.
But for statutory law marriage, it's monogamous. One man, one woman.
Okay, that by statutory means marriage under the Act?
Marriage under the Act, yes.
Okay.
Governed by the principles under the Matrimonial Causes Act.
Okay.
And so it's the validity of this type of marriage that we are looking at now.
Okay, the validity of the statutory marriage.
Statutory marriage. Yes, so the first one is that, like I said, both parties must be single. You must not have been married to any other person at the time of contracting the marriage. If it happens that the person has been in another traditional marriage or even another statutory marriage, it's an offense and it's punishable by between 5 to 7 years imprisonment. Yes.
So what sort of offense would that be?
That offense is known as bigamy
Okay.
under the law, and it's punishable between 5 years to 7 years imprisonment.
Okay, so do people actually sue on that?
Unfortunately, we rarely have such cases in our courts.
Okay.
We rarely have such cases. But an aggrieved woman whose husband has gone to marry someone else can actually take an action to court, but we rarely have such cases.
Because even in the courts, there are situations where the judges even delve into the arena and they ask
Yes.
you, how many wives did your father have? How many wives did your grandfather have?
Exactly. So the society we are in, but then it doesn't mean it's not an offense.
Okay.
And so you must be very careful before you enter into a statutory marriage. You must make sure that you are single. If you are married to someone else, there must be it must be divorced. You must have divorced fully and have your decrees before you enter into another statutory marriage with someone else. So that's one of the conditions. Then another conditions for a valid marriage is that the parties must not be within the prohibited degrees of consanguinity and affinity.
Those are big words you just used for us.
Well, I will explain what it means. Well, by virtue of Section 3 of the Matrimonial Causes Act, we have certain bloodline relationships, certain persons you are related to by blood that you cannot get married to. It is prohibited under the law. For example, a man, you cannot marry your sister, you cannot marry your mother's sister, your father's sister, your brother's daughter, your sister's daughter. So these are prohibited under the law. So if you have such a relationship, it cannot go, such a marriage will be void if you decide to go into marriage, to be void completely. So it's invalid under the law.
Okay.
Yes. So that is one. Then we have another condition which must be satisfied. That is the issue of marriageable age.
Marriageable age?
Yes.
Okay.
Both parties must be of marriageable age. Now, the Matrimonial Causes Act did not define what marriageable age means, but we can have recourse to the Child Rights Act. Okay. The Child Rights Act states that anybody who is 18 years can get married under the act.
Okay, so therefore anybody less than 18 cannot get married under the act.
Yes, that's what the Child Rights Act says.
So is it that the Child Rights Act actually limited it only to statutory marriages?
Yes, it limits it to statutory marriage.
It doesn't make provision for customary marriages?
No, it doesn't make provision for customary marriages. Another sad thing about the Child Rights Act is that it's not applicable in all countries of the Federation right now. At present, just about 23 states has adopted it. Okay. So in the other states, most of them are just,
that's quite
carrying on
sad
the way. It's quite
we
sad.
We still have issues of cradle snatching, child brides, and things like that.
We have a lot of it. Actually, the problem with this is not just our laws per se. Most of our laws are borrowed. Now, before the Child Rights Act came into existence, we were making use of the English laws, borrowed English laws, and by virtue of the English laws, they said any child or anybody who has attained puberty is old enough to get married. So most these things are the reason why you see some people still marry girls that are 12, girls that are 13, because if you really search deep, you may see certain laws that will even support it. But I'm very glad that we have our child rights law now. It's very, very important. Those states who have adopted it, they have done the right thing, because of the negative effects of getting married to girls that are actually 13 and 14, heard cases of VVF and all that.
Okay, so are there other conditions that would make a marriage valid under the Matrimonial Causes Act?
Yes, one of them is consent. Both parties must consent to the marriage. There must be no vitiating elements, maybe fraud or duress. A man or a woman must not, by trick or by fraud, make someone else to marry them. It must be there must be consent from both sides. So if there is any trace of fraud, duress, such a marriage is invalid. It is void ab initio. Then we also have other conditions. One of them is that the other condition, for example, you have situation where people who are married outside the country, maybe they got married overseas and they come to Nigeria. Now, how do you tell if their marriage is valid in Nigeria? Now, the law is that once the marriage is valid in the country where the wedding was celebrated, where it took place, it is valid in Nigeria. no matter even if it is not in consonance with our own laws here. As far as it is valid in the land where the marriage took place, it is valid in Nigeria. That is what the law says.
Okay, quite interesting. And Essay James-Omokaro has been talking about conditions that would make a marriage valid under the laws. She actually started by telling us that there are different types of marriages. The marriage under the Act is a statutory marriage. That's a marriage under the Matrimonial Causes Act, the Marriage Act. We have the traditional or the customary marriage, and that one is essentially polygamous. And we also have the one under the Islamic law, which is also polygamous.
Sure.
We want to take a quick listen to our reports on marriages and our legal nuggets. We'll be right back. Stay with us. Marriage, also called matrimony or wedlock, is a culturally recognized union between people called spouses that establishes rights and obligations between them, as well as between them and their children and between them and their in-laws. Article 16 of the Universal Declaration of Human Rights declares that men and women of full age, without any limitation due to race, nationality, or religion, have the right to marry and to found a family. They are entitled to equal rights as to marriage, during marriage, and at its dissolution. Marriage shall be entered into only with the free and full consent of the intending spouses. Marriage can be recognized by a state, an organization, a religious authority, a tribal group, a local community, or peers. It is often viewed as a contract. When a marriage is performed and carried out by a government institution in accordance with the marriage laws of the jurisdiction without religious content, it is a civil marriage. However, in Nigeria, there are two major classes of marriages under the Matrimonial Causes Act. 1. Statutory marriages. 2. Customary law or traditional marriages. Islamic law marriages fall under the category of customary law marriage. Statutory marriages are monogamous in nature, while customary law marriages are generally polygamous. This is still the courthouse, and this week we are talking about marriages, and we are looking at how a marriage should be, what constitutes a valid marriage. And we still have Essay James-Omokaro, a legal practitioner, telling us about what constitutes a valid marriage. And you were talking about the fact that if a marriage was celebrated outside the country, because a lot of times these days people go outside the shores of Nigeria to contract their marriage, celebrate their marriage, and they return. And you say now the law recognizes such marriages?
Yes, that is the position of the law, where the Nigerian law recognizes such marriage as far as that marriage is valid in a country where it took place. It is valid here in Nigeria.
Okay, so if it is valid there, you know, under our laws, we've defined marriage as between a man and a woman.
Yes.
So if a marriage is contracted outside the shores of this country by parties who are of the same sex, an issue that has become kind of worrisome these days, would that marriage be considered valid in Nigeria?
Well, those are the kind of cases where you have an exception in Nigeria.
So tell us more about
Yes, and that is clearly because our laws here in Nigeria is against homosexuality. That one has been passed. It is it's one of the laws of this country. So if the marriage over there between a woman and a woman, or a man and a man, once it comes here, it cannot be valid in Nigeria. So those are some of the exceptions to the situation.
Quite interesting. Yes. Now, you also mentioned, you know, celebration of marriages. We're talking of statutory marriages now.
Yes.
A lot of churches have these registers that is signed, And sometimes cases have come up where the court will rule that there was no marriage between these parties.
Yes.
Maybe because of the place where it was celebrated and things like that. Can you give us some insights into it?
Okay. Now, you are right, there are so many of such cases. That is because such marriages were celebrated in a place that is not licensed. Now, before you can go on to solemnize your marriage, the thing is that you have two options. The first one is what they call court marriage. I'll explain what that means. Then the other one is what they call church marriage. Now, before you even get to that stage, you go to the registrar's office, the marriage registry close to the local government in your area, and get what they call a notice of marriage. You fill that form. Once you fill that form, it is now published so that if there's anyone who has an objection or a caveat can enter it. Or if there is no objection, you are issued what they call a registrar certificate. Okay. Now, with that registrar certificate, you have the option of either getting married in a registered place of worship or in the registry. Now, there are certain places of worship that are registered. The governor of every state has that power to give a certain place of worship a license. Now, any place of worship that does not have a license does not have the power to solemnize any form of marriage. So that is why anybody who wants to get married in a church or any place of worship, it's important that you find out if it is a licensed place of worship. Because at the end of the day, if you go there and get married, what you have is just what they call a church blessing. Just a church blessing.
So it's not a valid marriage.
It's not a valid marriage.
So with all the the train, the celebration, and
those are just colorful things to make the events to make the whole thing colorful. But the high point is that marriage certificate that is issued. Once you come with the registrar certificate, you give it to your church. After the solemnization, your church hands over to you the marriage certificate, which they have obtained from the marriage registry. The same certificate that is given to people in courts at the registry is the same certificate that is given to you at the church if you are married in a licensed place of worship. So it's very important. You must find out, is my church licensed? It's not just the fact that your pastor says you are now husband and wife. No, it's much more than that.
Or the church is big, or your pastor looks old enough to conduct marriage.
It's not about that. If you are concerned about just the blessing, then you can go anywhere. But if you want your marriage to be protected under the law, then it's very important that the church is licensed to solemnize marriages.
Quite interesting. Things we take for granted, but at the end of the day, they become very, very important when the chips are down.
That's true.
So thank you so much. But do you have anything you want to tell us about Marriage Act, maybe any reform you want to see, or any advice you want to give us other than the place of worship which you just mentioned?
Okay, reforms under the Marriage Act. Well, this issue of marriageable age, I think that is a lacuna. It's very important. These Matrimonial Causes Act have been there for a very long time, so many years. It has not been updated, it has not been reviewed. It's very important that the draftsmen should come together and make a provision in respect of that age of marriage. It's very important. Let it be clear, because by virtue of that lacuna, you can hear of child marriages because of different interpretations coming up from different angles. Let it be clear that the age of marriage, maybe for a man is 21, for a woman is 18. Let it be clear, so as to protect our little children.
And I think another very important thing is to make sure that this law is general. It's not only for some segments of the society,
yes,
like some states adopting the Child Rights Act and some states not adopting it. Exactly. I think it should actually be general. Well, we've come to the high point of today's discussion, our Bar Book segment, where we share Latin maxims, legal jargons, and things like that, just to entertain us. So what is your Latin maxim for the week?
Okay, quick quid plantator solo said it. Quick quid plantator solo said it.
Okay, it sounds musical, but what does it mean?
It means he who has lands has the appurtenances on it.
Okay.
Yes.
So you actually mentioned another big word, but we won't go into that because there are appurtenances on it. Okay, I'll stick with local celebrationis because we're talking about marriages today. So local celebrationis is the place of celebration. That's the place where your marriage was celebrated. You get to find out more Latin magazines in our Bar Book segments. And now we are going to be taking a listen to some of the answers provided by our legal experts to the questions that you sent in. We want you to keep those questions coming in, but first take a listen to this.
An arrest is basically, in layman's terms, picking somebody up in the commission of a crime or suspicion that the person has committed a crime and taking the person into legal custody. That's the simple definition of an arrest. Now, the criminal code and the constitution empowers both the authorities, the military, the police, and even civilians to carry out arrests depending on different circumstances as specified in the law. Now, an illegal arrest would be where generally speaking, let's use the police, would be where the police picks up someone outside the gambits of the authority and keeps the person for whatever altruistic reasons they intend to. So, for instance, you have incidences where the police carries out a stop and search, so to speak. They pick up somebody from the streets and move them into their vehicles, and next they find themselves from, say, Aja, they find themselves at Bagada or Akpanti, and they're asking for money for whatever reason to get them out and to bail themselves. Those are illegal arrests, strictly speaking. So now, in certain cases, you find out that with police looking for a suspect, and they don't find him, they go after the family members of that person. Pick up the dad, the mom, friends, siblings, whoever they feel would know where the person is. They go after the person, pick the person, and for lack of a better word, use the person as a surety, as insurance. Let me use that word. Use the person as insurance till the victim comes out or till the suspect produces himself. Now, that's totally unknown to law. If you don't find the person you are after, there's no way you should be picking somebody up in place of that person. Your arrest warrant, or if you are arresting without a warrant, should have an identifiable person. Once that person is not available, there's nothing else you can do about it. The worst case scenario is you pick up the person or the people around there, take their statements if you need to do that. You know, you take them in and say, oh, okay, can you help with XYZ? Where do you find him? Can you help us get him? Where do you know? Not arrest them and keep them indefinitely or tell them that you are here till this person comes, or go and produce this person.
I hope that that was sufficient answer to your question. And we'd like you to keep sending your questions in. But before we go today, we want to say a big thank you to Essay James-Omokaro.
My pleasure.
It was quite interesting having you in the house.
Thank you.
Okay, thank you so much. So if you have comments for us or you want to update, you can log on to our website on www.loveoplus.tv. We have numbers showing on your screen now where you can send messages to. And our email address is info@loveoplus.org. You can send your emails to that address and you can send your questions. We'd like to hear from you. I am Olomu-Agbodo and I say, don't just get mad, go get a lawyer. Bye for now.